Hello, wise grasshoppers. We have reached the final PowerPoint for our course, AP United States Government and Politics. I know. I'm excited. You're excited. We're all excited. Okay, so this is Chapter 9, Civil Rights. Before we continue, I just thought this might be something interesting for you all to do, an attempt in your mind or on your paper to define equality. What exactly could equality be? What does it look like to you? Could it be defined differently for you than your neighbor? For someone who is older than you? For someone who's younger than you? It's an interesting concept. So just give that some thought. Probably a good idea to know the definition of civil rights to start out. So please do keep in mind that our civil rights are protections that exist for individuals from discrimination based on things like race, national origin, where you might be from, religion, your sex, any other characteristics, anything that could bring about some discrimination upon you. And so this means that we are protected to ensure that we get that equal treatment under law, okay? So it does require that the government act to protect individuals. So the government does need to act. Just think of the civil rights movement and things that the government did, well, maybe didn't do initially, but did later on, in an attempt to protect individuals who are experiencing discrimination because of some of these characteristics. Now, this does stem from the 14th Amendment, which is interesting because the 14th Amendment can protect both civil liberties, which are protections from the government. Just think of your Bill of Rights, yeah. But it also can give us civil rights. So our civil rights stemming from the 14th Amendment specifically come from the Equal Protection Clause. And like I said it a moment ago, civil liberties can also come from this amendment, and of course the Bill of Rights. We talked about that last week. But when looking at the 14th Amendment, civil liberties are going to stem from the Due Process Clause. Okay. And you might come across these two terms, so I just wanted to make sure you had an idea of the difference between the two when discussing the Due Process Clause. You might see procedural due process and then substantive due process. Procedural due process refers to when the government is restricting rights, they've got to proceed using proper methods regarding enforcement. So procedural due process restricts how those laws are enforced. Substantive due process, and you're not writing this down on your note-taking guide, this is just FYI, regards the content of the law, okay? The actual content must be fair and reasonable when certain rights are restricted, like what rights are restricted. That has to be, or that's called substantive due process. For example, not everybody can get married. And I know some of you out there might be going, what? That's ridiculous. Well, no, not everybody can get married. Willow cannot marry somebody right now. She's too young. Just one example, and I'm thankful for that. Okay. So let's look at securing rights for those who are disabled. So the problem was back in the day that public buildings and facilities did not always accommodate individuals who had physical disabilities. So you're seeing some fairly powerful images here, I think. And so disabled individuals use some tactics to enact change, like protests, rallies and sit-ins, very similar things that were done during the civil rights movement in the 50s and 60s, is being done by the disabled in the 70s, and then later on in the 80s and 90s as well. Well, 80s, not really 90s as much. So we do have some change. We have some change as early as 1973, but the big change that I would know if I were you is the Americans with Disabilities Act. And that will be signed in 1990. If you want to call it the ADA, that's fine. Of course, realize that that's something very different if you're talking about court. The assistant district attorney. Did you guys get that? Okay. So what the ADA said is that there can be no discrimination in employment, in buying goods and services, or in participating in government programs, okay? So that cannot exist. Here you have an image of some demonstrators in the offices of the Department of Health, Education, and Welfare in San Fran. This is in '77, part of what was called a 504 sit-in, calling for a civil rights law for disabled Americans to be fully implemented. And 504s are plans for people, especially in, an educational setting, that ensures that if that individual has a disability, that disability does not get in the way of how their performance or their mastery of skills, how that is assessed. Okay? So I'd like you to think about this for a second, and I believe I've left you a space on your note-taking guide. So the question is, how does the ADA illustrate tensions between civil rights and federalism? Why don't you press pause for a second and record what you think? Okay? I hope that you wrote something down. Hopefully you recalled our lessons on fiscal federalism, right? Federalism referring to the idea that the states and the federal government share power. Fiscal federalism referring to that power can include monetary power, right? So the Americans with Disabilities Act was not always a very popular thing because it did place some significant burden on state budgets. Because even though the federal government required these things, it did not pay for these things. And do you guys out there remember what we call those? If you said unfunded mandate, you are correct. So all of a sudden, these states and these businesses now have to build ramps and elevators, accessible parking spots, and all of that involves money. So it does become an issue of federalism because the states are now being forced to comply with a policy that they did not write, that they are not equipped to handle. But if they don't do it, they're going to get in big time trouble from the federal government and essentially lose funding for things that they need funding for. Okay, so hopefully that was a good little look at something specific before we dive into the fight against segregation. But before we do that, I have a practice FRQ for you. So why don't you pause and take a picture if you would like. Now, our second FRQ on the AP exam on May the 11th is going to be a concept application, much like this, content analysis. So you'll have an A, B, and C. You might have a graph, you might not. Why don't you guys take 15 minutes and see if you can hammer out an answer? Or if you want to do it later, you can. And just know that I've included the rubric on the next slide. So there you go. Feel free to grade your own or ask me to help you out. Okay. Alrighty, let's look at the fight against segregation. I've got a little timeline here for you. A good place to start is with Dred Scott versus Sanford. Now, y'all, this is not one of your 15 required court cases, and hopefully you remember this from U.S. history last year. But do you recall that Chief Justice Roger B. Taney and his Supreme Court ruled that slaves were property and not, what do you think goes there? Citizens. I know some of you are out there answering along with me, and it makes me smile. I know I can't really hear you because that would be creepy, but just know I'm with you in spirit, okay? Alrighty, yeah, so slaves are property, not citizens. So that was a big blow to, you know, fighting racism, fighting for equality, and fighting against segregation. Next thing that I would ensure you recall are those, sometimes they're referred to as the Civil War amendments, sometimes they're referred to as Reconstruction amendments. So that's talking about Amendment 13, Amendment 14, and Amendment 15. Do you guys recall what the 13th Amendment did? If you're saying out loud it ended slavery, you are correct. So what executive order did that then make permanent? If you're saying Lincoln's Emancipation Proclamation, you are correct. And I'm giving you air 5. Or here, I'll even make a high five to myself so you can hear the noise. Ready? 1, 2, 3. Yeah. Or maybe I killed a bug. Who knows? I didn't kill a bug. All right. The 14th Amendment was passed after that, ensuring blank to freedmen and the blank, blank, blank to protect their rights. What to freedmen do you think? Citizenship is correct. And then the Equal Protection Clause to protect their rights. Now, guys, please do keep in mind, I know some of you are saying, but Ms. Hatter, what about the 14th Amendment as the Incorporation Amendment with the Due Process Clause? Good for you. But we're talking about civil rights right now, not civil liberties, okay? But I am proud of you nonetheless. And the 15th Amendment, what did that do, darlings? It did. It granted African American men suffrage. Yay! Good job, everybody. Now, was everything all, you know, sunshine and rainbows because of these amendments? No, absolutely not. It was still a really crappy situation. So in the late 70s, Reconstruction ends. You guys remember that? The Compromise of 1877, one of the 5 times a person has won the popular vote but not the electoral vote. Anyway. Reconstruction ended, the national government backed off. It was part of a deal it made with the South for them to accept Rutherford V. Hayes as president. So the national government stops enforcing those anti-discrimination laws as much as they were. There is much segregation and white supremacy in the South. This is where we see those use of black codes and blank blank. Do you guys remember the name for these illegal segregation laws? Yeah, Jim Crow, very good. And Jim Crow segregation is an actual example of something called de jure segregation. De jure, it's D-E-J-U-R-E. You have de jure segregation, which is actually segregation by law. And then you have something called de facto segregation, which is segregation that essentially just kind of happens. It's like a fact of life. Can you guys think of any examples of something that might be considered de facto segregation? If you think of some, feel free to bring them to our discussion on, when are we having that? Friday? Yeah, Friday. Okay. This also leads to the beginning of the Great Migration, which was a lot of black people moving from the South to the North. Can't blame them. Can't blame them, although it was not always better. And something that we don't have written down there that you guys might want to write out to the side is the attempts to disenfranchise. It's my favorite. It's one of my favorite D words, right? Disenfranchise. Can you guys think of some of those examples that were done by Southern states to take away political power from the black community? Go ahead, say them out loud. It'll be fun. I feel like I heard literacy test in the universe. Correct. I feel like somebody is saying poll taxes. Yep, yep, yep. Yep, somebody's saying grandfather clauses. Good. Okay, so there you go. So that, coupled with the Jim Crow laws in terms of transportation, entertainment, business, and education, really were utilized to restore the social order that the South wanted, right? And to try and keep the black community under the white community's thumb. And then in 1896, we have Plessy versus Ferguson. Again, not one of your required 15 cases, but one of your required 15 cases is the case that overturns it. So it would be a good thing to know, and hopefully you remember it from last year. But it established the blank but blank doctrine. Do you guys know? Separate but equal, that it did. It established the separate but equal doctrine. And this applied to everything. This legitimized Jim Crow and segregation throughout the South. It wasn't just for schools. It wasn't just for transportation. SCOTUS unanimously said that, or was it unanimous? I think there was one person who voted against and one person who abstained. Forgive me. So 7 members of SCOTUS said, you know what? This is fine as long as things are separate, but they're equal, it's totally okay. Of course, the issue with separate but equal is that what? Yeah, separate is inherently unequal. The two really cannot coexist. At least not in this example. And then something else that I thought we might want to revisit is in 1948, President Truman issued an executive order integrating the military or desegregating, whatever word you want to go with there. Totally fine. Okay? And that's when African Americans began challenging segregation in the courts. Okie dokie. Here you have an image of a young African American man consuming water from a segregated water fountain. This is in Oklahoma in 1939. And now it's time for the big one, the Mac Daddy, Brown versus Board of Education. Now, remember, this is one of our 15 required court cases, and we're actually going to go over this in depth tomorrow on Tuesday. So allow me to zoom through it now before we zoom on it tomorrow. Oh, play. Oh, guys, I had it all queued up. It would have been so much more funny. Let's try it again. Let's zoom through it now before we zoom it tomorrow. Better. It's a really horrifying picture on the YouTube video of it, by the way. Anyway, okay, so what happened here is Oliver Brown has a daughter, Linda, who he tries to enroll in an all-white school, and it's close to their home. She has to pass it on the way to her all-black school every day, and the school she goes to, it's not nearly as good as the all-white school. So Mr. Brown wants for his child what all parents want for their children, the best opportunity to get a good education. So when his daughter was denied entry to the all-white school, he asks the NAACP to help. And this is where we have the very famous lawyer. Anybody know who it is? Thurgood Marshall is correct, future Supreme Court Justice, first Black Supreme Court Justice. And again, I'll let the folks who did the presentation on this give us more information tomorrow. But one thing that Thurgood Marshall did in his arguments is he cited this doll study, okay? And what it did is it identified that younger African American children prefer to play with white dolls over brown dolls. And the Chief Justice at the time, Earl Warren, knew, by the way, recognized that that was wrong. That was wrong. And there were so many other things that were wrong. And he admitted that the separation of the races does cause harm. And they saw that the two schools in Topeka, Kansas were not equal. Now, here's where Thurgood Marshall was worried. He was concerned that SCOTUS might agree that African American children have been treated unfairly, but only because their schools were not equal to white children's schools. And he was concerned that that's where SCOTUS would stop, because if SCOTUS stopped there, do we have to have a Supreme Court case for every school? Does it just apply to schools in Topeka? Does it just apply to schools? He wanted to attack the entire separate but equal doctrine as a whole. And luckily, Earl Warren allowed for that. And so what the court ruled in this decision, so Earl Warren, like I said, he really fought to get a unanimous decision to show that separation of the races does cause harm. And so the separate but equal doctrine was overturned in public education, and this overturned precedent. If instead you'd like to write overturned Plessy, go for it, but that's what it did. Here you have an image of that doll study. A married couple, two doctors, were able to conduct this experiment demonstrating the psychological harm of segregation. Ugh. And there you have Thurgood Marshall standing there on the steps of the Supreme Court following their victory. Way to go, guys. Not surprisingly, there was some Southern resistance to the Brown versus Board of Education decision. In fact, there was so much resistance that there needed to be a second Brown versus Board of Education decision the following year. And Earl Warren, in the majority opinion, required speedy implementation to use all deliberate speed. But guys, Southern states lagged in compliance. I mean, what does with all deliberate speed mean? Can't you say that you're moving as quickly as you can, but money is interfering and you can't do it? And so by 1964, y'all, you have 98% of African American children in the South still at completely segregated schools. So I know I mentioned to you that what de jure segregation was a moment ago. Now it's unconstitutional, right? Jim Crow segregation, not okay. So instead we have this rise in de facto segregation, which is the separation of people not by law but by other factors. And I've listed a few here: residential housing patterns, gerrymandered school districts. I mean, you know, guys, these things happen. Where buses go, where buses don't go, and that brings up the whole busing. I mean, kerfuffle, that's one word for it. But I mean, I want you guys to think about this. What enforcement power does SCOTUS have? Hopefully you're saying none. Let's not forget about our discussion of Federalist 78 and what Andrew Jackson taught us. It was Andrew Jackson that said about Chief Justice John Marshall's decision in Worcester versus Georgia that Marshall has made his decision. Now let him in. I know I said Georgia, honey. Georgia's a bad word. Sorry, guys. He said that Marshall has made his decision. Now let him enforce it, because he can't. He can't enforce it. The Supreme Court doesn't have enforcement power. And then in Federalist 78, you have Hamilton arguing that the judicial branch is the least dangerous branch because they need the Congress, the legislative branch, and the executive branch to enforce their decisions. That's why it's really not until 1964 that we start to see a change in some of this stuff. Can anybody out there anticipate what's going to happen in 1964? If anybody said the Civil Rights Act, you are correct. So why don't you press pause and read this for a moment? I'll pretend that you're going to do that. So let's look at George McLaurin, who is admitted to the University of Graduate School, but is he really admitted? Look at this picture. You can see what's happening here. Thurgood Marshall probably could have used this photo to support a sociological argument about the intangible effects of segregation. I mean, you guys can imagine what he must be feeling like there. Also, the University of Oklahoma could probably say that this segregation didn't violate the Equal Protection Clause or the Brown versus Board of Education ruling. They might say, hey, he's got access to the same content, same opportunities, same location. But I mean, clearly we know that's not the case. Now, definitely, the Brown decision is going to help lead to affirmative action. So that's letter, I believe it's C in your note-taking guide. The Brown decision led to this. So what affirmative action is, and I'm sure you guys have all heard of it, are somewhat familiar with it, is it is a policy designed to address the consequences of previous discrimination by providing special consideration to individuals based upon their characteristics. Think specifically of race and gender here, disability as well. An example of affirmative action, forgive me, inaction, is that some colleges and some universities might seek to boost enrollment of African Americans and members of other racial and ethnic minorities by allowing in more applicants or applicants that may not be as qualified as other non-minority applicants, right? Opponents will call it reverse discrimination, and proponents will say, no, it's necessary to ensure equality. So I want you to come up with what you think, because I'm going to ask you about it in our Zoom on Tuesday, okay? So notice on your note-taking guide, I've left a little space for you that says one case and summary of decision. These 3 cases regarding affirmative action are not in your 15 required cases, but it's just a good idea to see how SCOTUS interprets the Equal Protection Clause of the 14th Amendment. And guys, if you're hearing Willow in the background, I'm sorry, there's just nothing I can do about it. And I hope you picked up on her Georgia reference a moment ago. When I said Worcester versus Georgia, she said, ew, I said Georgia. I've trained her well. Okay, so the first one is the Regents of the University of California versus Backey. So this was in 1978, and Mr. Backey, a white male, sued the University of California at Berkeley after he was denied admission to their medical school. He said he did some research and felt as though the Equal Protection Clause was violated because there were 16 seats filled by minority candidates that he believed he was more qualified than. And if you probably compared them on paper, he would have been. And so in this instance, the court did strike down the quota system, but they upheld affirmative action. In other words, affirmative action taking race into consideration when admitting a student is okay, but using numbers, having a quota system, that is not okay. And then you have Gratz versus Bollinger in 2003, and this was focused on the University of Michigan ranking their undergraduate applicants on a point system, some that were based on race and ethnicity, and the court ruled that point system unconstitutional, but yet again, race and affirmative action itself is okay. And then one as recently as 2006, Fisher versus the University of Texas Austin. The court yet again upheld the consideration of race in college admissions, and there was something even more recently involving Asian American students at the University of Harvard. I suggest you look it up if you find affirmative action interesting. So here's 2 more thinks for you. I know there's not a space, but we already kind of talked about this first one. To what extent was Brown versus Board of Education successful in ending racial segregation in schools? I think with our discussion on Federalist 78 and John Marshall and Andrew Jackson, we kind of covered that. And I'll ask you about this in the Zoom tomorrow, which is Tuesday. Do affirmative action programs further racial equality, or do the programs result in reverse discrimination? And to end that section, we've got another FRQ for you. So if you would like to press pause on the video and grab your phones and take a picture so that you can practice this. Again, this is similar to what your second FRQ will look like on May the 11th. So feel free to give yourself 15 minutes and give it a try. And don't go to the next slide until you're ready, or stop the video to not see the rubric. And there it is. So if you want, press pause, take a picture, look at it, see if you would have gotten the points. Or by all means, let me see, and I'll tell you if you would have gotten the points. Okay. 9.3, the Civil Rights Movement. Obviously, if we're looking at a chapter entitled Civil Rights, it makes sense that we would look at the Civil Rights Movement. So it was SCOTUS that kind of led the charge to end discriminatory practices. Other branches did lag behind. And, we kind of already visited as to why that is that SCOTUS was making all these decisions, yet nothing was getting done. It wasn't until 1957 that Eisenhower nationalized the Arkansas National Guard to walk the Little Rock 9 to school every day. So that was kind of a big deal. And then finally, we do have the first piece of civil rights legislation passed since Reconstruction, the Civil Rights Act of 1957. And you guys know that, oh, I'm sorry, Wyatt is not happy about this. You remember Strom Thurmond and his filibuster? He filibustered one of the civil rights pieces of legislation that was passed by, well, eventually passed by the Senate. He fought very vehemently against it, spoke for over a day. But I do want to make sure we understand the differences between some tactics to go about bringing change. You can have a social movement, and we've already, briefly looked at this. Large group of citizens organizing for political change. So the leaders in the African American community mobilized in an attempt to change the status quo through marches and other forms of rallies. And then civil disobedience, that's the intentional refusal to obey a law. And when you do so, you're calling attention to its injustice. Okay, so think of civil disobedience examples. Can you think of any?
Can I try this?
Yes. Well, I hope you thought of some. I'm going to show you some examples now. Of course, Rosa Parks not giving up her seat on the bus in Montgomery, Alabama, kicking off the Montgomery bus boycotts, allowing a not super well-known Martin Luther King Jr. to surge to the national spotlight, or certainly the spotlight in Alabama. And the Supreme Court did rule that the Montgomery bus laws were unconstitutional, even though the strikers had won that battle well before that decision was made. Here, of course, you have leaders of SCLC, the Southern Christian Leadership Conference in Birmingham. And there, of course, is Dr. Martin Luther King. Hopefully, when you were coming up with some examples of civil disobedience, some of you thought of the sit-in, the famous one that kicked off the movement at Woolsworth lunch counter in Greensboro in 1961. Perhaps you thought of the Freedom Rides, Freedom Summer. Good. Okay, foundational document alert. Everybody, this is the last of our 9 foundational documents that you must know for the AP exam on the 11th. And lucky us, I imagine this is not the first or the second time you've read this document. So I am going to speed through this quickly, seeing as though we're going to discuss this document more in detail when we get to Friday's Zoom. So the letter from Birmingham jail is a document that came about following a letter from white clergy in Birmingham, essentially trying to use their common ties, to God, with MLK, urging him and other leaders of this movement to really slow down their protests and employ moderation. And of course, hopefully you guys all know the famous line from the letter from Birmingham jail. Let's see if I can do it off the top of my head. The word wait. The ear pierces the nears of every Negro with piercing familiarity, because wait almost always means never. I wonder how bad I butchered that. I guess some of you will tell me on Friday. But this is very, very, very famous picture. This is one of the student activists, so perhaps from SNCC, Student Nonviolent Coordinating Committee, who went down to Birmingham, which was called the most segregated city in the South, to protest. And of course, this was on the front page of the New York Times. JFK said it sickened him and believed that the United States looked bad to the rest of the world because of this. So after this picture was published, Kennedy delivered his own famous civil rights speech shortly before his assassination, vindicating what MLK had to say in his letter. Okay. All right. So you, of course, can finish your stop, think, write, and we'll go over that on Friday. All right. So finally, Congress acts. Okay. We already talked about some of the civil disobedience that we've seen throughout the South. The top right picture is a famous sit-in. You have the Freedom Riders underneath that. And there you go, my dears, is a picture of LBJ signing into law the Civil Rights Act of 1964. And that's what we should write for letter F. And do you see all those people behind him? And do you see all the amount or the crazy amount of pens that LBJ has in front of him? Basically, LBJ does a teeny part of his signature, and then he gives a pen to whoever is around him because it's a momentous occasion, the signing of this piece of legislation. President Obama did the same thing for Obamacare. And that way you have a pen that was used to sign this piece of legislation into law because you were, instrumental in securing its passage. And so CMLK is getting one. The Senate Majority Leader is getting one. The House Minority Leader is getting one. Anybody who fought for this or played a role in its passage would get one of those pens to keep forever. So anyway, LBJ is not the first nor the last to do that. So what the Civil Rights Act of 1964 did is it was legislation outlawing racial segregation in schools and public places. So guys, just think of all the things that public places could include. Swimming pools, hotels, restaurants, movie theaters, all of these places, no longer can they segregate, okay? Also, this is kind of interesting. It authorized the AG, the Attorney General, to actually sue individual school districts that failed to desegregate. So if you still have school districts in the nation that are not following the Brown decision 10 years later, they can be sued. And guys, the federal government will win and the federal government will get tons of money or deny them funds. And there's just not a school that can do without. If they are, they're a private school. And even then they try to take federal money. And then a year after that, you have the passage of the Voting Rights Act. If you've seen the movie Selma, this is really kind of the aim of all the characters in that film. So this was legislation that following year, and if you just get these confused, just think C comes before V alphabetically, and the Civil Rights Act came before the Voting Rights Act numerically or chronologically as well. So it's legislation that outlaws literacy tests. So that's huge. It didn't outlaw poll taxes. Does anybody recall how we got rid of those? If you said the 24th Amendment, you're right, which was also 1964. And this also authorized the Judicial Department to send federal officers to register voters in any cities or counties or states that were really uncooperative or trying to continue to disenfranchise voters. And guys, no state, no city, no locality wants this to happen. They want to conduct the election on their own. They want to be seen as legitimate. And for the federal government to come in and do this, that sucks. They don't want that. Guys, federal funding could be cut if discrimination is occurring. And so no state wants to lose that money. Now, in 2013, there was a pretty significant ruling from the Supreme Court that found that part of this Voting Rights Act was no longer needed and thus unconstitutional. And if you think that's interesting, you should look up the case. It's Shelby v. Holder. And if you like, we can talk about it. Okay, press pause, take a picture of the FRQ. And just know that on the next page is the rubric. And here's the rubric. While some of you are taking a picture of this, let me just touch a little bit more on why the civil rights movement was so focused on getting legislation passed by Congress. They had already gotten so many things ruled in courts. Having legislation as opposed to an executive order really kind of shows the importance of securing the African American franchise for many reasons. One, to help African American presence be felt in DC. Two, because it's downright undemocratic to deny someone their right to vote for no good reason. Also, once there was federal law, it required states to comply. So that was a big deal. And it gives a nationwide standard that has to be followed. This is something that Brutus I wouldn't really care for, but the Federalists view to be very important. Okay, just wanted to reiterate that a bit. Okay, let's look at the last section for civil rights, the fight for women's rights. So I want to make sure you understand that women's rights kind of came in two waves. Oh, no. Well, that's not good. So on your note-taking guide, in 1920, we, of course, have the 19th Amendment. And do you guys recall that? Very good. I know you all said women's suffrage. Excellent. And then in the 1960s, this is kind of the second wave, you have the feminist movement kind of kick off. Do you guys remember Gloria Steinem and Miss Magazine? It's good stuff. If you have never read the article, what is it called? If Men Could Menstruate, I really suggest you look it up after this PowerPoint. It's just hilarious. Please check it out. If I can find it, I'll put it on the blog for you or on Schoology, whatever. Part of the reason why feminism really kind of kicked off to address the inequality and treatment of women and harassment of women was because there was this book called The Feminine Mystique, which was written by Betty Friedan. Friedan is F-R-I-E-D-A-N, Friedan. And the Feminine Mystique was really interesting because it shattered all of society's assumptions that women were happy as homemakers and mothers, and that's it. Now, Friedan recognized that there's plenty of women that can be, but she also suggested that the mystery of the feminine figure is perhaps that they want more than that. Okay? Perhaps they want more than that. Also during this time, NOW was established. Do you guys recall what NOW stands for? N-O-W? Good. It is the National Organization of Women. And then you, of course, have the Civil Rights Act of 1964. And that was a big deal for women because it prohibited discrimination in employment based on race, religion, and gender. So there you go. Women cannot be discriminated against anymore in employment. So when I was hired, Dr. Ritchie couldn't have said, hey, do you plan on getting pregnant anytime soon? Because if you do, I don't want you to come and work here because maternity leave wouldn't be good for AP government students. Yeah, he couldn't say that, right? He couldn't ask that. It's also women were wanting to ensure that it could be illegal to retaliate against employees who filed discriminatory claims. No discrimination in school for women, especially in institutions of higher learning. So all of that was a big deal that came about in that second wave of feminism. These are all images from the first wave. Oh, and there it is. Okay. Alrighty, I do think it's interesting to talk about this lady right here. So on the left, you've got Betty Friedan in a march commemorating the 50th anniversary of the ratification of the 19th Amendment, the author of the Feminine Mystique, excuse me, not Feminine Mistake, oh my gosh. And see her sign, housewives are unpaid slave laborers, ouch. Tell him what to do with the broom. So there's plenty of women who are pretty dang passionate during this time. And here's one of them. Ladies and gentlemen, allow me to introduce you to, anybody know who it is? There she is. It's Phyllis Schlafly, the head, basically, of the anti-feminist movement. And y'all, I haven't watched it yet, but Hulu launched on the 15th of this month, Mrs. America, and it's based on Phyllis Schlafly, and it stars Cate Blanchett. So you know it's going to be so good, so good. So I do need to watch that. So do you. Okay, so the next two pieces of legislation in 1972, we have Title IX of the Higher Education Amendments. of 1972 to the Civil Rights Act, okay? And what this was legislation prohibiting sex discrimination in schools that receive federal aid. But really what Title IX is known for is for having the impact of increasing female participation in sports. And there's a good TED Talk. You can just, Google TED Talk on Title IX, and you should watch it. Even though it provides women with equal educational opportunities in academics, like I said, most of the discussion focuses on athletics because Title IX of the Higher Education Act says that women can't be excluded from participating in or denied benefits or be subject to discrimination under any educational program or activity receiving federal aid. In other words, that includes sports, okay? So there has to be similar amounts spent on girls and boys sports. And that is a reason why when you get to college, especially in the Southeast, you'll find, I know this is the case, I think at Georgia and Auburn, that the women's soccer team is a varsity sport, but the men's soccer team is club. And that's in part because there are no women on the football team. So that's kind of interesting. If you want to know more, just email Coach Kelly and ask him about it. But don't just put Title IX in the subject line and freak him out, okay? Just say, hey, I'm in AP Gov and I got a couple questions about this, because I'm not an expert. Okay, also in 1972, but a little bit later, we have the Equal Rights Amendment. So this could have been Amendment 27, but it failed to pass. So what it states is that equality of rights under the law shall not be denied or abridged by the U.S. or by any state on the account of sex. See how the amendments now are including the federal government and the state governments? Yeah. Now, this did pass Congress. Both houses did pass it with what vote is required? Do you guys know? 2/3. But it did fail to get the required 3/4 of state legislatures to pass it. It was 3 votes shy. So it was originally proposed by Alice Paul in 1923. And this map shows you states that have ratified it, have not ratified it, etc. Virginia should be a different color now. They should be pink, which is kind of interesting. So you have feminist versus feminist, 2 different takes on the word. The middle class said, yes, we do want this to be passed. That way there's no distinction between men and women in the workplace. But the working class said no. They were concerned that they might lose their gender-based benefits, which include maybe not as many hours as their male counterparts. Women at this time weren't expected to work in the evenings or overnight, weren't expected to lift heavy equipment. Also, maternity leave. What if maternity leave went away and maternity leave and paternity leave were all of a sudden equal? I believe Cobb County gives you, 10 days for paternity leave maybe? Whereas for women, it's 6 weeks. So that's kind of interesting. So anyway, like I said, 35 out of 38 states ratified it. 5 later rescinded, and then a few more later ratified it. They extended it to 1982, the deadline, but it was dead in the water in 1978. So, but interestingly enough, there's been some changes. So feel free to look these up and we can talk about them on Friday. Now this is kind of interesting, guys, because we're talking about equality and we're talking about discrimination. The Supreme Court does say that you can treat people differently as long as it's reasonable. Now you don't need to, oh yeah, you do need to write this down. So this comes into play when we're talking about scrutiny. Okay, so reasonable classification, according to SCOTUS, means that the government does have the power to make what are called reasonable classifications between persons and groups. Okay, a few examples of this if you'd like to write some down. You cannot vote if you're under 18. You can't smoke if you're under 21. Also, if you smoke, you've got to pay an excise tax on the sale of cigarettes. Same thing if you consume alcohol. So, those are going to affect people differently. And some people are going to be subject to those taxations, and some people are not. But then you get into the concept of strict scrutiny. Strict scrutiny is classification by race or ethnic background. If you have a law that is different for folks because of race or ethnic background, that law is going to be suspect, and it's got to meet a strict scrutiny test. It's got to be justified by a compelling public interest. So in other words, no people can be treated unequally deliberately if it's by race or ethnic background. Most cases that are subject to this have been struck down. A good example would probably be Loving versus Virginia. That was a case in, I want to say 65. Richard and Mildred Loving, they were an interracial couple. And Virginia said interracial couples can't get married, but they loved each other. They wanted to get married. And so the Supreme Court ruled that that law is suspect and it has to go through a strict scrutiny test, and there has to be a compelling public interest, and SCOTUS found there was not one. So that's an example of one of those particular laws being struck down. Can you think of any other examples? If you can, bring them to our discussion on Friday. And this just kind of shows you the different levels of scrutiny. Feel free to look into that on your own. I'll discuss it a little bit more here in a second. So other classes going after equal protection. Age. Age is not a suspect classification. So those laws don't have to show that compelling public interest. Okay. However, Congress is sensitive to, oh my gosh, this makes me so happy. Gray power, power of the old people. There's so many of them. They pay their taxes, they receive entitlement benefits, and they vote. So there is federal employment protection against age discrimination, but they are not suspect to strict scrutiny. Those laws are not. Sexual orientation, it is not automatically treated as a suspect class. I want you to think about how you feel about that. Are there other factors that influence that? Do you think you might see that change anytime soon? It's a good question. Gender discrimination and sexual harassment. So women are not suspect to strict scrutiny. They fall under a rational basis standard. Differential treatment for women has to be shown to be reasonable and not arbitrary. And most of these forms of treatment do differentiate gender or race, are found to be unconstitutional. So harassment in the workplace, there's a couple kinds. There's quid pro quo. I'm sure we're familiar with that phrase, right, guys? Maybe the employer's request or demand a sexual favor in return for a promotion or a job or an opportunity. Or there's hostile work environments where there's actions or statements or conditions that unreasonably interfere with the ability of the employee to do their job. Let's say your boss sends you really inappropriate text messages or shows you pictures at work. That's not okay. That's harassment. That's a hostile work environment. Interestingly enough, though, women are not subject to the draft, and the court has upheld that. So that is an example of a law that is different for gender that is constitutional. We're going to skip that. Okay, let's look at some other races and ethnic groups and the struggles that they've faced and accomplishments they've seen. So how about Hispanic Americans? Now the largest minority group in the United States. They've experienced a lot of racial discrimination, employment, housing, immigration laws, quotas. And there's a lot of present discrimination against what I just said, immigrants, right? The controversy over how to deal with the illegal immigrant problem, President Trump's executive order granting amnesty, the DACA program, President Trump's executive order with travel bans. So there's a lot that group is dealing with. Oh, I forgot to blow that picture back up. Whoopsie daisies. Okay, Native Americans or American Indians, they have a legacy of really a terrible one, forced removal and assimilation efforts, right? Continuing discrimination and just terrible poverty, guys. Rates of alcoholism, suicide, depression are really in their highest on Native American reservations. It's sad but true. Drug use. Since the mid-1900s, the government has extended more rights and protections to this group. Oh no. Oh no, okay, good. I didn't leave out Asian Americans. I would have felt really bad. You guys should check out the article that I posted about Native Americans taking over Alcatraz, by the way, if you think that would be interesting to read. Unclaimed land, it's really fascinating. Asian Americans, a lot of these individuals face real significant discrimination in terms of employment and housing, etc. I mean, goodness gracious, let's not forget about the internment camps, right? The Japanese internment camps of World War II. Arab Americans and Muslims. Obviously, since 9/11, there have been an increased number of bias-related assaults and other violent incidents towards this group. Issues of treatment of suspected terrorists. Hopefully you remember Guantanamo Bay in Cuba. And hopefully you remember the question I asked you when we were going over the executive branch about Obama wanting to close that and that not happening. I feel like we already talked about the disabled community. There's a bunch of links that you can watch. I'll post those in a separate document. And then what about the LGBTQ plus community? They've definitely faced discrimination, hiring, housing, education. I mean, you name it, essentially. That's very old. I need to replace that. Of course, their most recent achievement is Obergefell versus Hodges. I have to write it out. ER. Hang on, guys. This is terrible. Liz, learn to spell. Okay. Obergefell is Obergefell, and then Hodges. Obergefell versus Hodges. Yeah. And that, of course, said that gay marriage is constitutional and must be allowed and recognized in all states. And there's a couple cases that SCOTUS was set to hear regarding employment treatment of transgendered individuals. So that should be interesting. Maybe I'll have to update my note-taking guide by next semester. So let's go through that. Alrighty, so equal rights today. Obviously, a lot of legal barriers to equal protection or participation have been removed, right? The growth of the federal government, though, in scope and authority cannot go unnoticed, guys. It is happening. And states have something to say about it. Some critics feel as though a lot of the civil rights progress has really just benefited the middle class, not growing what they dub underclass in urban areas. Some critics say that the socioeconomic divisions are more pertinent than racial divisions. And really we need to look at it as an SES problem as opposed to a racial problem. And then other people say that we need to completely revive the civil rights enforcement and attack residential segregation. There's a lot of directions we could go, guys. I think it's safe to say it is not done. So I want us to talk about this on Friday. I really want you to think like a political scientist, okay? Where do we go from here? Really, as Americans, as America, as Americans, how do we ensure that civil rights continue to be upheld? What group is next? What are they struggling with? And do you think that it's a civil rights issue? All right. This is the last slide, folks, for AP U.S. Government and Politics. I hope you've enjoyed it. I know I have. It's been a real good time. I'm really looking forward to celebrating when we can together in a non-social distance way. See you at our Zooms. Come on. Yeah, it's a celebration. Bye, grasshoppers.